work that your firm has done in helping people who need counsel. The Professionalism Commission that Judge Battaglia chairs and has organized is something that recognizes that kind of effort, and I hope it'll continue. Thank you very much.
I will let them know. Thank you, Your Honor.
And you're always welcome back.
Thank you.
Thank you. Number 19. Ms. Green.
Good morning, Your Honor. May it please the Court, my name is Andree Green, and I am here on behalf of the Maryland National Capital Park and Planning Commission, Prince George's County Planning Board. We are here today to ask the Court to overturn the judgment of the lower court in that, and state that the plain language of the general plan evinces the District Council's clear intent on how this objective of the general plan is to be monitored and applied. The implementation of the general plan is based on, as clearly stated in the general plan, we will monitor this progress, we will monitor the growth in the rural tier to see how well our other regulations are working to reach this objective through the biennial growth plan, and see what further regulatory revisions might be necessary to reach this objective. The first biennial growth objective update came out in 2003. At that time, it showed that the county was not meeting its intended goal of less than 1% of the dwelling unit growth in the rural tier at that point.
Is it your position that the findings that the judicial review has concluded should be made by the planning board, is it your position that the planning board doesn't have to make those findings, or is your position the planning board sufficiently made those findings?
Our position is that the planning board is not given the jurisdiction to make that type of finding at the time of preliminary plan.
It's a little different. You're saying they don't even have the right to make those findings?
As to the less than 1% growth objective of the general plan. To make that finding.
So it's not they made the finding, it's not they aren't required to make the finding. It's essentially they don't have the right to make the finding.
Correct.
Okay.
To make that finding, the planning board would have to have some type of regulatory authority. They would have to be able to enact laws to control that. If you assume that, the approval of a preliminary plan equals growth, which the county doesn't, then still the county council as the governing body would need to enact some type of regulation in the subdivision ordinance stating that.
Well, if you could only determine growth after the lot has been finally approved, then how do you ever implement the plan set forth in the general plan or the master plan?
First of all, a preliminary plan, even if it goes to final plat, does not vest a person in the ability to build.
I understand. I'm asking different questions.
There are any number of ways you could do it, and different counties do it different ways, but most counties do it at the time of building permit. They have a queue, and they allow so many building permits per year.
And then they put a moratorium?
No, you get in line. And let's say you have 3 subdivisions approved that year, and in order to meet the goal, only 3 subdivisions totaling 150 dwelling units. And the county has determined that in order to meet that long-term goal, we can only have 75 houses built this year. So you get in a queue, the applicants get in a queue, and the first 75 in that queue go forward.
Well, why hasn't it worked?
The county hasn't enacted that. They haven't done it. They would have to enact legislation to do that.
Oh, so you're saying that they,
Under your argument, it's effectively toothless at this point.
Well, it's not toothless to meet what the county stated as its reason for doing this. It clearly states in the general plan that we're going to see if our current mechanisms will reach this objective, this
What are
end.
those mechanisms if not subdivision?
We have a new green infrastructure plan. We have, they enacted conservation subdivisions. There's a new woodland conservation ordinance going through. There's the HART program, which purchases development rights in the rural tier to preserve the environmental features and the farmland. They have instituted certain mechanisms that they envisioned would help this. But clearly from the data that the Commission has put together, it's not working. And let me not say it's not working. To date, we are above the 1%. But this is a long-range goal to 2025.
The standard is for the year 2025.
That's correct.
I mean, arguably, and I'll use some gross terms here, I mean, offensively gross, but you could go to 2020 exceeding the less than 1% standard on an annualized basis, and then just suddenly stop.
That is
And
correct.
say, we're going to let things flush out over 5 years other than in the rural tier, because then by 2025, we'll have less than 1% if we freeze development in the rural tier.
Building permit.
But there's no present standard in Prince George's County statute by ordinance that provides teeth for this standard, is there? There's no basis to deny a building permit for a residential unit in the rural tier because it would otherwise not conform to the recommendations of a master plan or general plan.
No, there isn't. And how would you gauge that if the goal is 2025? How would you say we need to have only X number today in order to reach that goal of
There are
2025?
many conceivable policy justifications that even the planning board could make a finding at the time of subdivision why approval of this subdivision with the number of units is not inconsistent with the numerical, I'll call it the cap or the goal of residential development in the rural tier.
And they have done
Today.
that. They've done that in the past. In the Archer's Glen case,
Why
they
is,
did
why,
that.
is, why is the planning board picking this issue to fight about?
Because
If they've done it in the past,
Mm-hmm.
they didn't do it here. That's clear, yes?
that's clear.
But they've done it in the past. Why are you
The reason-
standing and fighting on this
Because
when you have already multiple menu of answers?
we did it in Archer's Glen because that case got remanded from the circuit court. And we thought, the board thought it prudent at that time to do an evaluation of it.
Even though it had no legal authority to do it, according to what you're arguing to us today.
Yes. It wasn't until it became apparent to the board that this was a significant issue that was being raised on numerous occasions that we looked at it. And we realized this is not something that the board should be evaluating at the time of subdivision for a number of reasons. One, the basic one, is that the general plan does not contemplate that. The other basic issue is that subdivision approval, preliminary plan approval, does not equate with growth. The county has hundreds of recorded lots that are 30, 40 years old that will never be built. Subdivision just does not equate growth. It isn't until the the building permit is pulled and the unit is on the ground, that you actually have what the general plan envisions controlling.
So the hyperbola in your brief about if this court were to agree with the Court of Special Appeals, there would be a freeze on further subdivision approvals in the rural tier is not true.
No, it could be true. It could be true. If the planning board had to, on each subdivision case, make a determination, which I think would be difficult, but I'm sure we could find some statistician to do it, make a determination if the approval of this subdivision will not meet the goal of less than 1%.
That's not what the Court of Special Appeals opinion remanded it for. You could have, for the reasons we talked about earlier, there are almost an infinite number of policy responses to the master plan goal that do not compel denial of a discrete preliminary plan today because of some objective that may or may not be reached by 2025. What the planning board chose to do here was to completely ignore it, not even respond to it. That's why the Court of Special Appeals said, go back, address it. One way of addressing it might be, well, it's not growth yet. We don't know if there will be dwelling units. We don't know 10 years from now whether we'll have 1.4% of the county's growth in the rural tier, thereby not meeting our goal of less than 1%. There's lots of answers, but the simple declination of even addressing this master plan principle is what the Court of Special Appeals said. Go back and respond to it.
The general plan principle. What the planning board is concerned about is that a different court, a different circuit court, a different panel on the special appeals might not accept what you just said. They might not accept the planning board's reasoning for saying this doesn't necessarily defeat the less than 1% goal, the objective.
Well, it strikes me that we could take care of that in the opinion that gets filed. And what this court ultimately files will control at least judicial review of whatever happens administratively.
And that's why we felt it was important to ask you to review this, because we have another case right behind this one dealing with the same issue.
But it doesn't necessarily follow, though, counsel, that we should, or that we must under the law, say that the board, as I think you, in answer to your earlier question of Judge Harrell, you don't have the right. You're asking us to declare that the board does not, the Planning Commission rather, does not have the right to make the finding.
That this is not, that's preliminary plan of subdivision is not the appropriate, let me not say appropriate, it's not what the general plan scheme envisions. The district council is absolutely aware of how to affect preliminary plans of subdivision. They've done it in the past, and if they want to, they'll do it in the future. They didn't do that in the general plan. They simply said, we're going to monitor this, and we're going to see how well our current programs are working, and if we need to do further regulatory revision. Only the district council can enact laws. The planning board can't. I think it might be a different case if the planning board could, because then the planning board could say, well, the general plan says that we should be doing X, and we need some type of a regulation to implement X. But the planning board cannot do that. The planning board simply has to follow what the law is.
Can you give us a glimpse of what other provisions of an applicable master plan or as amended by the general plan the planning board may not consider in a subdivision approval?
Well, there's economic principles, there's housing principles, there's the master plans and the general plans speak to a whole wealth of...
When the subdivision ordinance said that improving a preliminary plan of subdivision it's supposed to conform to the recommendations of the master plan or the general plan as it amended the applicable master plan. It didn't really mean that, is what you're saying.
No, I think it did. It does mean
It
that.
meant conform to some things but not other things.
It meant conform to the issues that are relevant at the time of preliminary plan.
Nobody spelled that out. That's
Nope.
going to be done on an ad hoc basis.
No.
There's no adopted policy of the planning board that says, well, here are the things that we can't even consider.
No, what the planning board does is look at the things that the law speaks to at a preliminary plan that the master plan also speaks to. For instance, density. The subdivision requires you conform to the master plan, and it conforms to the zoning ordinance as far as density. Environmental features. Master plans often speak to preserving certain environmental features and how lots will be laid out. All of that is in the subdivision regulations or in the zoning ordinance, and it speaks to the recommendations of the master plan. In the rural tier, the master plan and the general plan both speak to preserving environmental features, large areas of farmland, designing the subdivisions to accommodate and preserve as much of the environmental and scenic and farmland as possible. All of those things are preliminary plan issues pursuant to Subtitle 24.
Planning board then legally, putting aside the individual facts of the case, could legally deny approval of a preliminary plan of subdivision for a parcel of ground that had recently been in active agriculture because it violates the master plan encouragement to maintain agricultural properties in the rural tier.
I would have to say no, because the master plan
So
also...
that's another master plan thing that can be ignored.
No, because the master plan also speaks to preserving landowner equity and allowing large lot subdivisions. What they could, the planning board could deny is a subdivision request for urban type dwelling, urban size lots, an urban subdivision. That would not be in keeping with the goals and the recommendations of the master plan and the general plan. But in a large lot subdivision is in keeping with one of the goals of both the master plan and the general plan. That's the problem you run in with saying that each subdivision must comply with every point in the master plan or the general plan, because it can't. It just physically can't. You can't preserve agricultural land and allow large lot subdivisions. You can design your subdivision to the best you're able, preserve and protect these environmental features, these large open areas that can be farmed, but both the master plan and the general plan seeks to accomplish all of these things, not on any one particular property, but in the area. And so you might have a large lot subdivision next to a farm. You might have a HARP easement over a large property, which is which removes the development potential to preserve the farmland. One of the other things that concerned us greatly about the Court of Special Appeals decision was the idea that if someone brings it up, an issue up at the hearing, regardless of whether it's relevant to a preliminary plan, the board must address it. That's of grave concern to us, because if you just look through the general plan and the master plan, there's any number of issues that just cannot be addressed at master plan. Housing type, streetscapes, all of these are detailed site plan, specific design plan issues for another time, not preliminary plan.
And in 25 words or less, that could be explained and it's over and done with.
Yes.
It's the risk of ignoring it is what's brought you here today, I think.
Well, what we're concerned about is we don't want to have to come here at every,
If your argument is that the opposition to this subdivision plan didn't more fully put on its evidence about why approval of this application would exacerbate the county's continuing inability to meet the growth objective in the rural tier, capping the growth objective, wasn't there more to the Court of Special Appeals opinion? I mean, that seems to be the focal point, is this numerical growth objective, and whether or not the planning board had to confront it in some fashion and explain it away. But I thought that Judge Davis's opinion gave other reasons for why this case goes back regardless of whether you prevail or your colleague prevails on the numeric growth consideration.
I thought it was because the court said that we didn't address it.
I thought there was more to it than that. My worry was that even if you prevailed on the numeric growth, it still goes back under the Court of Special Appeals. Other reasoning, which you have not picked much of a fight with here.
It might, and we would not have a problem with that.
Well, it seems implicit in the opinion is there would be judicial review, if requested, of whatever happens once the planning board addresses the issue and makes a statement of perhaps why it's premature at that point to pass on it.
I go back to, we're concerned that if we have to address this issue, one, because it goes against the plain intention of the council. I don't think there's anything in the general plan, in the scheme laid out in the general plan, that shows an intention for this to be a subdivision issue.
There's nothing explicit that says you can't consider it.
No, there isn't. But the planning board generally does not look for things to opine on. They generally follow the law. That's their role.
So there was no, never mind.
Thank you, ma'am.
Thank you.
Mr. Nelson.
Please, the Court, Macy Nelson on behalf of the citizens appellees in this case. My clients are asking this Court to affirm the Circuit Court and the Court of Special Appeals on the theory that what those courts did was very narrow. It was not extreme. It was really modest. And what those courts said was to the planning board, you need to articulate findings that address this 1% growth objective, and there needs to be substantial evidence in the record to support those findings. Here, the planning board simply ignored the issue. Judge Harrell asked a question, well, was there anything else in that Court of Special Appeals opinion? And what I took from the Court of Special Appeals opinion, because I've been doing a lot of these rural tier cases, is the court said to the planning board, if you look at the staff memorandum, and if you look at the staff report, and if you look at the resolution, the formatting is essentially the same. The words are almost identical. And at that point, Judge Davis said, let us pause now and reiterate the point, which is, these are my words now, it's essentially a copy and paste job. There's no independent fact-finding by the planning board, which is the fact-finder, and the court spent a page or two emphasizing that, and that's what we have here. And the court also observed that the findings in this correction, not the findings, the words in the resolution track the words in the resolution of another rural tier case. It's all the same. It's on the computer. They hit Control P, and the resolution comes out affirming the preliminary plan.
Doesn't mean they didn't consider the fact.
Well, we can go to the language of I was responding to Judge Harrell's question about was there something else in the opinion, and I think that's what else I believe is in the opinion. It's evidence that there wasn't a fair consideration of it. But the real point here is we believe that, my clients believe, that there needs to be substantial evidence in the record of compliance or of the 1% issue, and articulate how, if you don't meet it, excuse me.
that's a two-edged sword. The testimony of one of the folks from your group on this subject of the numerical growth objective is pretty thin. It's conclusory is what it is. They didn't put on any evidence. They made a conclusion. They're not meeting the growth objective in the rural tier. They're exceeding it. If it weren't for the fact that the commission fleshed it out in its appendices with the details of how much over it is, you wouldn't have any evidence put on by the opposition in this case. You'd have a conclusion. Now, is that enough to generate the need to respond? I mean, it would seem to me the need to respond ought to be because the statute, the ordinance says, you got to find that it conforms to the recommendations of the master plan or the general plan as it may have amended the master plan.
May I have a paragraph to answer?
Sure.
All right. My client was pro se at that hearing, point one. Second point, a pro se client cannot, because she fails to articulate fully the legal theory, cannot waive a legal obligation that the planning board has to follow the law. So one response is my clients didn't, it's always better to be present. It's always better to fully articulate the argument. It's always better to have a lawyer there. I understand all that. But there's no obligation for a citizen to take the day off from work, go to a 6-hour planning board hearing, and tell the planning board what the law is. That's not their obligation. The planning board has the obligation to follow the law. Now, we're learning as we go along. There are a number of cases, and we will now, next time we try a case, we will argue the updates, as Your Honor just alluded to. There is data, but this is data that the planning board has. It's part of the general plan. The general plan requires the assembly of this, the compilation of this data. So I would say the data is there, that we didn't have the obligation to present it, but there is no dispute. The trend is getting worse. It went from 1.4% to 2% to 4%, and my colleague argues, well, planning board approval doesn't mean anything. But if we look at the master plan itself, at extract 190 in this case, the master plan, which my colleague concedes is binding, says every recorded subdivision is a legal commitment to development, extract 190. So I would say that my client did put the issue in play fairly. The court, my colleague understood that the issue was in play. The Court of Special Appeals understood the issue was in play, and the court properly said to the planning board, you need to articulate how you meet this standard, and there needs to be substantial evidence to support it.
Assuming we agree with you, how do we write it? That it's a sort of a burden-shifting issue, that the issue has to be raised by the protestants, and if the protestants say they aren't complying, then the burden shifts to the developer or the petitioner to demonstrate compliance. Of course, here we're dealing really with not so much burdens of production or persuasion. We're dealing with what judicial review on 2 levels has concluded to be a non-finding that should have been made. That's the way I read what the circuit court said and what the Court of Special Appeals said. They didn't make findings that they were required to make, so it has to go back for those findings.
Correct.
All right.
But your question is, how do we draft, how does this court draft the opinion?
For example, even though your client was pro se, if your client went in there and said, now there are 25 reasons why you should deny this, and articulated the 25 reasons and didn't mention what now is perhaps the most important, there are cases that say that argument is waived and can't be reasserted. If, on the other hand, it's sort of a jurisdictional situation where this is an absolutely required finding before anything else is to be done, then maybe the issue doesn't have to be raised at all.
Well,
but I wouldn't want to say, just because it's a pro se as opposed to, somebody who's represented by counsel, that we're going to throw out all of the cases in which the court has said that you don't raise it at the administrative level. You can't raise it for the first time on judicial review of the administrative decision.
May I respond to that narrow point?
Sure.
I've looked at that issue very closely, and there are judicial reviews of administrative cases where an appellate court has held if the party doesn't raise the issue at the administrative level, you can't raise it on appeal. In each of those cases, it was, for example, a physician licensing administrative hearing, or where the party who didn't articulate the point is not a citizen challenging a government's decision to approve a development, but it's where the person is a party in the process. And the point I've made many times, and hasn't resonated yet, which is in the land use context, where an agency, in this instance the planning board, is obligated to consider an application for a subdivision, the planning board has the obligation to follow the law, whether or not a citizen with or without attorney comes in there and says, this is the law. We don't have the obligation to educate them as to what the law is. They're the professionals. They have to follow it. These cases are different from a case where a physician's license is at issue before the Office of Administrative Hearings. So I would say we don't have to raise it. It's always better to raise it because it makes it easier for the fact
Your
finder.
position is you want us to hold, essentially, that this issue can be raised for the first time in judicial review. Actually, it would probably be dicta under the facts of this case, because I think enough was said about
yes,
it.
and I would say that, strictly speaking, that issue of whether you have to raise it below is not before this court, because the court didn't grant cert on that issue. No one asked for cert on that. It's a very interesting issue. So I don't think it's, strictly speaking, before this court. What's before this court, I believe, is whether the planning board has the obligation to, on the basis of substantial evidence, articulate how this plan comports with the 1%.
And Mr. Nelson, on that point, forgive me because I didn't get the reference, but you're saying that the board, the commission, had the obligation to follow the law, and the law that you're or the specifics of the law upon which you're relying. I think you gave us a cite to the record extract. I think it was a line from the master plan.
Oh, yes, that was extract 190.
190, and is it that statement alone upon which you rely in making your argument that the commission should have, or was obligated, to use your word, to consider the numeric growth objective?
No, I was actually, perhaps I didn't speak
Well, no, it was my omission. I wasn't
The point I was,
intending this
with respect to
characterization.
the statement of extract 190 in the master plan, that statement says every recorded subdivision is a legal commitment to development. I cited that in response to my colleague's argument that what really matters is when the building permit is issued. That's how you monitor or track development. And I simply wanted to point out for the court that, well, wait a minute, the master plan itself says that the recorded subdivision is a commitment to development. So I was responding to her narrow assertion. Now, my point is that, with respect to your question, was I say that the general plan 1% rule is binding, and they have to articulate how they're going to meet that standard, and there needs to be substantial evidence in the record to support that.
And it has to be, and that determination, in your view, you're rebutting the position that the Park and Planning is taking today, and in its brief, that it doesn't have the right to make it. You're at polar opposites in your view of what the obligation is. You're saying it's a must, not a can or a may consider it at the subdivision stage, but it's a must.
It's a must. But
And the other side, as I understand, is saying it's a must not, or a may not, I should say.
But our statement, our assertion is quite modest, because all we're asking for is a requirement that there be substantial evidence supporting a statement of how the planning board is addressing this 1% rule. As Judge Harrell said, our target is 2025, so some years we may be a little bit below, some years we may be a little bit above, some years we may be right on it, but you need to address it. And here, if you look at the data submitted by my colleague, the trend is upward.
But responding to Ms. Green's argument that, at a certain point, it's not the planning board's job to assure compliance with that. The planning board can say, well, approval of this application at this point in this calendar year would be X% of the total county growth for this calendar year to this point, and compare it. Raise the red flags that if you're not tending the garden every year, you're going to find yourself 15 years down the road
In trouble.
Unable
Right.
to meet the objective that you set out. But to deny a preliminary plan in 2008 that we're not going to be able to meet the objective by 2025 is saying quite a bit.
Well, of course, I'm not arguing to this court. I'm arguing in support of a remand to articulate on the basis of substantial evidence how they're going to comply with the rule. At the planning board, if this court does remand, we will argue that there, but that's not what we're arguing here.
You'll want to come back here, I'm sure, if we say, well, you at least have to address it. We're not telling you how you have to address it, but you have to address it. No matter what they say, if it doesn't comport with your client's view of it, you'll want to come back. I understand that.
May I shift the focus ever so slightly about the general plan? One of the subtexts of my colleague's legal position is that the master plan is binding, the general plan is not. And we argued this issue before the Court of Special Appeals, where there was a reported opinion cited in our papers. Judge Jim Eiler wrote the opinion, and when we learn as we go along, and when I argued that case, when I briefed that case, I didn't have the benefit of listening to a presentation by Ms. Wasserman where she articulated in a seminar her view as to why the state law, Article 66B, requires counties to adopt a comprehensive plan and requires counties to adopt subdivision ordinances and regulations to implement the objectives of the comprehensive plan. And I believe that her argument is powerful. I believe it's an independent basis to say this general plan is binding on the planning board. And I would urge the court there's so many Archer's Glen cases. Judge Jim Eiler's opinion?
Yeah.
Well, yes. He said something different. What he said was at 176 Maryland App 325, this was where he was rejecting my motion for reconsideration. He said the general plan amended the master plan with respect to countywide goals, objectives, policies, and strategies. The master plan is binding and became is binding, and because the objectives, including the growth objectives, were made part of the master plan, they are binding. So what Judge Eiler said was, master plan was amended by the general plan, and now the 1% rule is binding, subject to the substantial evidence test on the planning board. My argument I just made is slightly different. What I'm saying is the general plan as an independent document is itself a binding document. It's a subtle difference, but it's different. Yeah. my clients are grateful that this court's taking the time to look at this issue and look forward to the court's opinion. Thank you so much for your attention.
Thank you, sir. Ms. Green?
Thank you, Your Honor. Three things. I'm going to have to take issue with you, Judge Harrell. You stated earlier that the general plan didn't specifically say how this objective would be met, monitored, measured, whatever, but it does. It specifically says we're going to monitor this, we're going to evaluate this
I
through
don't
the...
recall saying that. If I did, of course, I misspoke.
Okay.
My point was, it didn't say it had to happen every year.
No.
And it didn't say the planning board didn't have a role in it.
No.
And it didn't say the planning board could ignore it.
No. But it did say, we are going to monitor this through the updates to see what needs to be done to meet it. If they wanted it to be monitored,
Once they've monitored it, where's the implementation part?
well, that's up to the county. The county has to do that. And in fact, in the provision of the master plan that Mr. Nelson cited at extract 190, it goes on to say, if today's regulatory tools are not enhanced and are supplemented, suburbanization of an increasingly larger part of the study area will continue.
But why is it, when they say they're going to monitor it, and they may take additional
Steps.
measures, updates,
No, not updates, regulatory revisions to ensure this goal is met.
why is it logical to infer from that the planning board can't be a body that assists in the implementation of that goal?
We could be, if legislation is enacted directing us to do that. That this is how the county intends to achieve this goal. We are going to enforce this at subdivision.
What's the general authority of the planning board?
It's through Article 28, but the district, well, for subdivision, it's the county council and the county exec as the governing body enacts the subdivision laws. And the planning board has no authority other than to implement those subdivision laws. One of the laws of subdivision states that a preliminary plan must conform to a master plan.
Okay,
And
why isn't, when the master plan states the goal, they're required to comply with the master plan and the general plan, why shouldn't they be making findings about whether that goal is
because the county decided that it wanted to monitor this through the updates.
But that's not, why is that inconsistent with the planning board making findings?
Because the planning board can't do anything with that information. If the planning board monitors through subdivision, they can't still do something to meet that objective. The district council can, and it envisioned that it would. There was an update in 2003, there was another one in 2008, which clearly shows the trend.
But all they can do is what? Stop the building permits?
Well, no. There's any number of legislative actions that the council could take. They could,
you're right.
they could do some rezoning. I mean, there's...
Let's pretend that it's the final Thursday in December of 2024.
Mm-hmm.
The planning board is in session. This application comes before it. The evidence is that to approve this application, you would then have 1.1% of the county's growth occurring in the rural tier. If you didn't approve it, you'd have 0.99%.
Mm-hmm.
Planning board can't, law doesn't change. We disagree with your explanation of what constitutes growth. Planning board has no ability to deny that application.
I would have to say yes.
Okay. That clarifies where you are.
I'll also point out that someone raised a question about what other things in the master plan and the general plan speak to goals, objectives that the planning board would not touch. There's economic and employment opportunity section, not relevant at preliminary plan. There's a section on taxes, not relevant at the time of preliminary plan. Structure design, not relevant at the time of preliminary plan. Landscaping, community revitalization, all these things are spoken to in the master plan and the general plan, but they're not relevant at the time of subdivision. According to the Court of Specials opinion, if it's raised, if someone were to come in to say, in the rural tier, how are you addressing, through this development, community revitalization? According to the Court of Special Appeals, we would have to address that. If someone came in and said, how is this subdivision adding to employment opportunities in the rural tier? We would have to address that. Just because it's in the general plan, or even the master plan for that matter, because these plans speak to huge areas, it has to be addressed, it's supposed to be addressed, it can be addressed at subdivision.
Is there some policy document that, let's suppose a citizen walks in off the street, goes in to the county administration building to the 4th floor and says, I'd like to know what parts of master plans have nothing to do with the subdivision process. How will they find that out?
It's in the master plan. The master plan is broken down into
And it says
development
this doesn't apply
patterns.
subdivision?
No, it's broken down into development patterns, economic, environmental, and stages like that. What you have to look to is the law. You have to look to how the law implements these goals and objectives. Without the law to implement these goals and objectives, they don't get implemented. They can't be implemented. There has to be a procedure, a mechanism for the planning board to use to implement these goals and objectives. When you're dealing with a master plan, there are specific goals and objectives and laws and regulations that coincide with it for the planning board to use. This is not one of them. And I think it's very important in what the general plan says. I mean, this is the same council that enacts the subdivision laws, that enacts the zoning laws, that approves the master plans and the SMAs. They know how to do things. And if they wanted this particular goal to be implemented at the time of subdivision, they could have easily said that instead of saying, well, this is how we're going to monitor this, and we're going to check back on it and see what else we might need to do to make it continue.
Counsel, on that very point, does the master plan otherwise say at subdivision stage, planning board, you are to consider X, Y, and Z?
No, it does not.
Well, then,
the law says that.
That's where I have a problem with that argument.
The law says that. The law says it must comply with the master plan and, by association, the general plan. But you have to read into that it has to be relevant, otherwise it just doesn't make any sense.
Who compiles the biennial update?
The commission, not the planning board.
And that's the monitoring that the district council was talking about.
Yes, yes.
Could you just briefly, for my edification, run me very quickly through the procedures that happen after the preliminary site approval?
Depending on the zone, you can either go straight to final plat, or you might have a requirement for a detailed site plan, and then you go to final plat, and then you would go to building permit.
Final plat is also decided by the board?
Yes, yes. But just quickly, the recording of a subdivision does not equal growth. It can't, because subsequent to development of that property, the land could be rezoned.
Well,
the law could
it does
change.
equal the right to have the land subdivided.
Yes.
So later on, if you go to the county and they say, no, you can't build, isn't the landowner going to have a constitutional claim against the county eventually?
Not if they have invested. If they have invested prior to the change in the law, then no, they have
The
no.
county can't prohibit them from building forever. If they've
No,
got-
but what I mean is,
they've got a subdivided lot.
but you could change the zoning of that subdivided area so that your once 5-acre zoning is now 25-acre zoning, and so you can't build 5 lots. You can only have one house. You
You've already
can,
got your lots.
it doesn't matter. The current state of the law, the case law, is that if you don't have substantial development going, you're not protected.
Thank you all. Number 21.